Thank you, Xavier. Welcome to the third and final session of the day. The only thing that is standing between you and, I think, free time and pre-dinner drinks is this session. This is the Court's Contemporary Issues and Debates, or as I like to think of it, the How Good is Queensland session. It's my privilege today to introduce two members of the Queensland chapter of the Society, each of whom is a scholar and a gentleman. To the extent that they are both camping out, as our former Prime Minister would say, in Queensland, then I highly recommend a good hard dose of camping out in Queensland to the rest of you. And might I suggest to the former Prime Minister that if you're a person who is camping out, rather than just quaffing socialist champagne in Sydney, that might make you more qualified for public office than not, and better able to make a contribution to our federalist system than otherwise. Our first speaker is the Honourable Paul Howard, who is a Justice of the Federal Circuit and Family Court of Australia, Division 1. He is, without doubt, a judge who knows the law of the kingdom and is willing to keep it well, and that is something he does every day. Justice Howard was called to the bar in 1990, where he practiced primarily in succession law and family law before being appointed to the Brisbane Registry of the Federal Magistrates Court in 2007. His extensive experience working through complex family law trials and finalised in excess of 4,500 family law cases between 2007 and 2021, when he was appointed as a judge of the Family Court of Australia, as it then was. In 2018, Justice Howard completed the Fulbright Scholarship as a visiting foreign judicial member at the Federal Judicial Centre in Washington, D.C. He has lectured extensively on his research domestically and internationally, and has published extensively on Australia's family law system. Please join me in welcoming Justice Howard.
Thank you, Robin, for your kind words. Alan Myers, ACKC, Stuart Wood, AMKC, Xavier Boffa, members of the Judiciary, members of Parliament, former members of Parliament, ladies and gentlemen, how wonderful it is to be here in Western Australia. I got a bit worried earlier when Ian Callanan mentioned the family court. I thought, oh, look out, we're going to cop it now. But it was very, very Christian words spoken, of course, by Ian, and I was able to relax. There's been a lot said over the course of the last, well, I suppose, day and a bit, about the uniqueness of Western Australia. And I haven't spent a lot of time here over the years, but the more time I do spend here, I come to realise, I think, that Queenslanders, where I was born, of course, Queenslanders and Western Australians are like siblings who were separated at birth. Because as soon as we meet up, there is a meeting of minds. And there's something to be said for it. I mean, our favourite sport often is poking fun at people from Sydney and Melbourne. But in all seriousness, it's almost a state of mind. It's interesting because I'm talking today about the history of the Family Court of Australia. 50 years old next year. January, there will be, or on the 5th of January, it'll be 50 years since the commencement of the Family Law Act, and that's the date when the Family Court came into existence. And where's Mr. Warner? Mr. Warner had a lot to say this morning that was, I thought, interesting at the time, and I reflected on it during the day. And I think he could be right in this respect. Family law and what happened in relation to the Family Court is a very good example of where Western Australia stood apart. And Western Australia did not join in on the Family Court, the National Family Court, when it was passed. It chose, as it was entitled to do, to create its own family court, the Family Court of Western Australia, and consequently, to the very great advantage of the people of Western Australia, a lot of the shenanigans that have transpired these past 50 years on the eastern seaboard, the Western Australians have avoided it. So, Mr. Warner, hats off to you again. I think you might have nailed it. Robin mentioned that we have a new name. The family court is now called, unbelievably, the Federal Circuit and Family Court of Australia, Division 1. Not to be confused with Division 2, which is where I used to be, which had previously had the name the Federal Circuit Court of Australia, and before that it had the name the Federal Magistrates Court of Australia. So the courts are now linked but not merged. It's a legislative beast, the likes of which you've never seen, but it does seem to work. It does seem to work for a number of reasons, and I'll explain that shortly. But I would say this, to examine the history of the family court is to look back at a snapshot of Australian history from the late 1960s onwards. Everyone knows that that period of time was a period of great upheaval in the 60s, with the advent and the widespread use of the contraceptive pill, with the strong desire to change the status quo, with the questioning of authority, the questioning of everyone in authority, from police to teachers to parents. There was the Vietnam War, and there were the moratorium marches, and the universities where more and more young people were going became hotbeds of protest. And as that decade grew on, members of the legal profession in Australia, and especially those who were practicing in family law, they started a bit of a movement. They were really the main proponents for a change in the area of family law. And when Mr Whitlam's government was elected in 1972, reform of family law was firmly on the agenda. With the enactment of the Family Law Act in 1975, there came into existence in Australia for the first time what we call no-fault divorce, and of course the family court also came into existence. So 1975 you had the family court established. It operated by itself in this respect as the sole federal court exercising jurisdiction in family law for 25 years, until the creation of the next court, which for convenience I'll call the Federal Circuit Court. Then for 21 more years those two worked in parallel almost, until they were eventually linked together with one head of jurisdiction. So it's just easier though, because most Australians know what you're talking about if you call it the family court. It's easier for me to call it the family court and the Federal Circuit Court. As you're all well aware, Section 71 of the Commonwealth Constitution grants to the Parliament the power to create federal courts, and the Family Law Bill 1974 was introduced in August of that year into the Senate by Senator Lionel Murphy. The leaders of the major parties gave to the senators and to the members of the House of Representatives a conscience vote. Senator Murphy, of course, was appointed to the High Court of Australia in February 1975, and the new Attorney General, Kep Enderby QC, then became responsible for steering the bill through the Parliament. Members of the Society will be well aware of the contributions made by Senator Murphy and Mr Enderby QC to the debate. Their contributions are widely remembered and well known. But a review of the parliamentary debates from early 1975 reveals that many more members of Parliament spoke in the debate. More than 60 members of the House of Representatives wanted to be heard. Members such as Andrew Peacock, the member for Kooyong, Paul Keating, the member for Blaxland, William McMahon, the member for Lowe, John Howard, the member for Bennelong, Ian McPhee, the member for Balaclava, Dr Jim Cairns, the member for Layla, and Philip Ruddock, the member for Parramatta. All of these members of Parliament spoke in favour of key reforms that were contained in the Family Law Bill. They didn't all necessarily agree with every aspect, but they all spoke in favour of certain key reforms contained in that Family Law Bill. Now, the bill itself passed through the Parliament in May of 1975. It received the royal assent in June of 1975, and as I said earlier, the Act commenced in January 1976. And as the members of this society will know very well, that certain momentous events occurred between those two dates, between the Royal Assent in June of 1975 and the commencement of the Family Law Act in January 1976. There were the momentous events of November 1975, when the Whitlam ministry was dismissed, and at the subsequent federal election, Malcolm Fraser's coalition parties, if I could put it that way, were returned to office. So in Australian history, therefore, it will be recorded that it was indeed Gough Whitlam's Labor government that created the Family Court, and it was Malcolm Fraser's coalition government that nurtured the court for the first 8 years of its existence. One of the names mentioned earlier this afternoon by the Honourable Dyson Hayden was Bob Ellicott QC. He became the Attorney General of the Commonwealth on the 22nd of December 1975, and Bob Ellicott was responsible for the appointment of the first 25 judges to the Family Court. Western Australia stayed separate and apart from this national family court regime. But my goodness, Western Australia have had a lot to say about the National Court. They've been very involved, and I'll explain that in a bit more detail. Senator for Western Australia, the Honourable Peter Durack QC, became the Attorney General in September 1977, and he served in that office until March of 1993. So whereas Ellicott was there for the first year or so as the Attorney General, a West Australian, Peter Durack, was very much involved in the first formative years of the Family Court. It's important to note also, for instance, the contribution to the court made by people like Lionel Bowen, who was the Attorney General during Bob Hawke's Prime Ministership. For 6 years, Mr Bowen provided strong support to the Family Court and to the judges of the court, and during this time the court thrived. Through the 1990s, though, it became more and more apparent that there wasn't really a great need for superior court judges, that is the judges of the Family Court, to be dealing with a lot of the family law applications, the more mundane and more straightforward ones. One proposed reform was that there might be a second tier of judges within the Family Court. However, the government of the day, led by John Howard, with the assistance then of another Western Australian, Darryl Williams, AMKC, decided that a new court would be created. So there was a West Australian coming in, essentially, with the proposal, and it was enacted, for the creation of what was then called the Federal Magistrates Court, what I'm calling today the Federal Circuit Court. As I said earlier, those two courts worked side by side for 21 years. After 21 years, another Western Australian, a man who was here earlier today, Christian Porter, became the Attorney General. The government came to the conclusion, after 21 years of two federal family law courts, with two different sets of rules, two different sets of procedures and processes, and different leadership, the government came to the conclusion that the country could no longer afford to have two courts operating basically in parallel. So what did they do? An opportunity arose, and when Mr Porter was the Attorney General, he was in a position to appoint, and he did appoint, our current Chief Justice, William Alstergren. We now have William Alstergren as the Chief Justice of the Family Court and the Chief Judge of the Federal Circuit Court, which means, whilst there's still two courts, there's one set of leadership. He's ably assisted by Justice Robert McClelland, the Deputy Chief Justice of the Family Court and Deputy Chief Judge. In 2021, the Parliament enacted what is colloquially called the Focaccia Act, the Federal Circuit and Family Court of Australia Act, 2021. As I said earlier, only the bureaucrats could have come up with the name, and the legislative scheme is a sight to behold. But nonetheless, as I also said earlier, it does seem to work. If you look across the span of the 50 years, no matter what way you look at it, no matter who was in power in Canberra, no matter who was the Chief Justice, the judges have always just been responsible for getting on with the work. They've all been devoted to duty, and at times it's a trying jurisdiction, and that's for sure. We've had significant increases in resources, and that's very much to be appreciated. It is a very great credit to the governments of both sides of politics that they have since 2021 continued to provide significant resources in the area of family law. There's more judges, there's more registrars, there's more judicial registrars, there's more counselling services, there's more alternate dispute resolution services, and all of this is good news for Australians. In its 50-year history, the Family Court has endured a lot of change. There's been many amendments to the legislation, and many of the members here will be well aware of what they were. At times, the court has been criticised, of course, we all know that. And I think that's just it's a product of the nature of the work, of course. Everyone thinks they're an expert in family law because everybody thinks that they know about relationships and about the raising of children. And we have a lot of self-represented litigants who come into the court, and it takes quite a while to disavow them of their expertise. So it's been an interesting ride. I've been involved integrally on the bench in this area now for 18 years. And there's many Australians, I've only named some of them, who've played prominent roles in the history of the Family Court and indeed the history of the two linked courts. And it has to be remembered, if you take one thing away from this talk, that the Family Court has to be remembered that its fate has been linked this past 25 years with the fate of the Federal Circuit Court. I'm not sure what will happen in the future, who knows, perhaps one day there'll be some legislation to harmonise the whole thing and put us all together in one court. But never mind, as I say, at the moment, the waiting times for litigants have been reduced. The work is being processed quicker than it ever was. And this, of course, is the most important aspect from the point of view of the Australian population. History will record the contributions of people such as Elizabeth Evatt, who was the first Chief Justice, Alastair Nicholson, who followed her, Diana Bryant, the West Australian referred to earlier this afternoon by Ian Callanan, John Pascoe, who was Chief Justice and Chief Judge of the Federal Circuit Court as well, William Alsegren I've mentioned, many, many others as well. When it came to the reforms that were needed in 2021, it's important also to keep in mind the contributions made by members of this society, including the Honourable Amanda Stoker, who was the Assistant Minister to the Attorney-General from 2020 to 2022. So I think I'll leave you with this thought in relation to the Family Court, and then by all means, if anyone has a question or two, that's fine as well. Western Australia stayed separate and apart, but Western Australia has still had a lot to say in relation to the regime of national family law and the National Family Court. I think that separateness has enabled them to bring in a certain objectivity, so that time and again Western Australians have had to step in, as it were, to assist with the way the courts are structured and the way the courts are headed. And just to list those people again finally, so you don't forget, I'm sure the West Australians won't forget: Peter Durack, Darryl Williams, Diana Bryant, Christian Porter and Michaelia Cash, just to name some of the West Australians who were integrally involved in the 50-year history of the Family Court of Australia. I hope you've enjoyed that snapshot. It's not straightforward. That's because the history of the family court hasn't been straightforward. There was a period of time when there was much upheaval early on and a lot of controversy. Hopefully those days are behind us. It seems that they are. There's altogether now a very strong sense of collegiality and camaraderie between the two courts, which is excellent.